Hello, everyone. Welcome to another episode of Gray Matter. Before we get to our guest, I just wanted to mention the very sad loss of a true Canadian freedom fighter over this past weekend, Leon Fontaine, who is a Canadian broadcaster, Christian broadcaster, heading up the Miracle Channel. And as I said, a real freedom fighter, inspirational leader to his congregation and to many, many thousands of listeners and followers. Passed away suddenly. He was only 59 years of age. So tremendous loss to our community, those of us on this side of the case. And Leon will be very, very sorely missed. I had the pleasure of being on his show, his podcast a couple of times. He also was a guest on our program, and that's a blessing that we have that recording. And we're going to be replaying that in memory of him, in memoriam of him. Today, we have another freedom fighter, actually someone whom I've called a national treasure, former politician, now a statesman, I think would be the correct way to describe him. I had the pleasure of meeting this gentleman this past August in Calgary when Tamara Lich received a Freedom Award, and I got to listen to his stirring speech. And it's Brian Peckford. He's back for another round with us. A lot has happened since the first time that we spoke to Mr. Peckford about 8 or 9 months ago. And so we want to get an update on some of the things that are going on with him. He's been very active in both in our courts and in the public media and on his blog. And we want to mine some of his best thoughts about some of the things that he's writing about and speaking out about in the, really in the public forum. So for those of you who don't know, Brian is former Premier of Newfoundland. He also is a publisher of his own blog, and significantly, he's the last living signatory and one of the crafters of our Canadian Charter of Rights and Freedoms. And one of the things he's lamented about is how the Charter is being interpreted and applied in this country. And hopefully he's going to talk about that a little bit. If you want to learn more about Brian's very, very interesting biography, I encourage you to listen to the earlier episode where we go into in depth about his background and how he got into politics and his memories of that really incredible time when the Charter was being gilded and made part of our Constitution. But today, we're going to talk about some things that are, let's say, more current. Before we do that, we're going to go to our aphorisms board. And again, these have been chosen in Brian's honor. Hopefully you won't be offended by these. The first one is from William Penn from 1668, who famously wrote, "Those who will not be governed by God will be ruled by tyrants." The second one is from the late John F. Kennedy. We just got through the 59th anniversary of his assassination, sadly, but he wrote many things. But one of the things that he said in one of his speeches was, "Do not pray for easy lives, pray instead to be stronger men," and women for that matter. The next one is from an American journalist and economist named H.L. Mencken, who died in 1956, but he wrote something about 70 years ago that I found that it really, really is relevant to today's times. He wrote, "The whole aim of practical politics is to keep the populace alarmed and hence clamorous to be led to safety by menacing it with an endless series of hobgoblins, all of them imaginary." I rather think that our guest today would agree with that one. And then finally, because I know that our guest is a lover of literature, I've chosen one from English literature, Rudyard Kipling, author and journalist. This is a very famous one. I know Brian will know this one, but he once wrote, "If you can keep your head when all about you are losing theirs,
I'm blaming it on you."
There you go. "If you can wait and not be tired by waiting, if you can trust yourself when all men doubt you, yours is the earth and everything that is in it."
And once more, my son.
I'm so glad that resonated with you, Brian. So welcome back to the program. Thanks so much for being with us again. It's a real pleasure to have you back and to talk with you.
I don't know when we spoke before, when we went through my biography, I might have mentioned it. The story about when I went to university first. I was from the Bay in
Right.
Newfoundland, from rural Newfoundland. And at that time, the university had not very much wisdom, even though that's what the universities are supposed to be all about. And so they had initiated, as all wonderful government institutions do, another regulation as related to people who couldn't speak English properly. And therefore, that qualified for all rural Newfoundlanders who had to take a speech test because they had this accent, which perhaps people can recognize even to this day when I speak. And that accent, somehow or another, graded the people at the university, and therefore we weren't speaking properly. And therefore we had to take this test to see whether we had to take a special speech course in order to qualify to be at the university in the first place. Well, I was, of course, automatically and instinctively opposed to this thing. I didn't know anything about it when I applied to the university. But here I was in university, staying at a boarding house in St. John's. And I had to go to this particular room and sit down with two professors, and they would give me something to read, and they would decide whether or not I should be subject to this regulation or not. So I walked into the room and closed the door and stood up. And the professors asked me to sit down. I said, no, I don't want to sit down. I want to stand up, which I thought was my first way of telling them that things were not going to go as smoothly as it has with every other student that came into the door who was taking this test. And so they said, what do you mean? I said, no, I don't agree with what's going on here. Well, they said, we want to see how your speech is. So I looked at them and I said, it was a lady and a gentleman. I said, lady and gentleman, it little profits that an idle king by this still hearth among these barren crags. And on I went with Ulysses. I got halfway through Tennyson's Ulysses when they put up their hands and said, stop, stop. And I kept going. And when I decided it was time to stop, I stopped. And they looked at me and they said, you can go now. You won't have to take it.
This reminds me of a story that Dr. Roger Hodkinson told me. We had him on the program. And he was from Northern England, I believe. And he went to Cambridge. And he said that when he went to Cambridge, he lost his native accent, and he said that this is one of the greatest regrets of his life, that he doesn't sound, when he goes back, he doesn't sound like the place where he's from anymore. And he feels a great loss. Yeah. Anyway, good. Speaking of English history, maybe we can start about talking about your Magna Carta project. You want to tell us a little bit about is it the new Magna Carta? Is that the correct way to describe it? Or how would you describe your Magna Carta project?
Well, I describe it as just my Magna Carta for today, because two things happened when I got involved in this freedom exercise that you will appreciate, and which I've talked about on a number of occasions. One was, as I began to speak and oppose what was happening in our country as it related to the pandemic and all of the lockdowns and mandates and so on, I said to Carol, my wife, one morning, after we were engaged in this for a number of months, there's one thing to talk about it. There's another thing to do something about it. Not only, talk the talk, but walk the walk, so to say. And so that's when I began to initiate the lawsuit with the Justice Center, opposing the travel mandate that the federal government had instituted last fall. And secondly, as I began to do more and more speaking, I also thought that I should, if I oppose something, that I need to put something in its place. I need to say something and propose something which I believe at this point in time in our history is better. And so that's when I came up with my Magna Carta, and I outlined it, I think it was in May of this year, on the steps of the legislature building in Victoria at one of the freedom rallies there. And so what I was trying to do was to outline a series of things that could be done under the existing Constitution, could be done tomorrow, to help correct some of the flaws that are now present in our system. And the first one had to do with the political parties, the federal political parties, all ensuring that they have a audited financial statement of their organization every year and post it on their website. Right now, if you go to the websites of all three of the main political parties in the House of Commons, you will not find anywhere on their websites an audited financial statement of their finances as a political party. So one has to ask the question, one of these parties, all three of these parties want to be the government of Canada and manage billions and billions of dollars a year, and yet we don't know how they manage their own budgets as a political party. So I thought that would perhaps be the first thing that could be done automatically for all three political parties to agree to that. Secondly, I proposed, which I thought was a simple matter as well, that the present conflict of interest legislation, federal conflict of interest legislation, has a number of loopholes. One of which is that a member of the House of Commons can break the conflict of interest law as determined by the Conflict of Interest and Ethics Commissioner and still sit in the House of Commons. The Prime Minister of this country today has broken it 5 times since he was Prime Minister and still sits in the House of Commons. So how easy for an MP to bring in a motion or a resolution to the House. And I mean, it would embarrass all the rest if they didn't go along with it and say, I want, here's an amendment to the conflict of interest legislation. We can pass this in a day, do first reading, do reading and principle, second reading, do committee of the whole, because there's only going to be one clause, right? Any MP cannot sit in this House if they violated the conflict of interest law as determined by the Conflict of Interest Commissioner. And so I sent that off to the leaders, and of course, the silence has been deafening. So those were the first two that we could do automatically to establish integrity and ethics, which are now missing in our public square as it relates to our federal political parties. Those two things alone could help bring back some degree of credibility to the House of Commons and to the federal political parties. And so I propose those, plus a range of other things like balanced budgets. It could only be violated if there was a war or insurrection, and many, many others. Education, I propose that the authorities responsible for education in the country be obligated to bring in legislation whereby a particular civics course would have to be presented in grade 8, and there would have to be a follow-up course every year until they graduated from high school. In other words, they would get 4 full years of civics. And that civics must be about Canada and Canada's politics, Canada's governance structure, from the federal government to the provincial government to the municipal government. I've already done this myself as a former teacher and introduced it into the school that I taught in for 4 or 5 years. So I know what I'm talking about, and I know it's possible to do, because one of the great lessons out of this pandemic has been the lack of understanding of how our country operates. 2 days ago, 48 hours ago, I was contacted by some health professionals about a new bill going through the legislature of BC as we speak, today and yesterday and the day before, massively reforming the health professionals' governance system of the province. Nobody knew anything about it. The health professionals who called me and asked me what they should do, how could they react to this? They didn't have a clue about how the legislature worked. What was second reading? What was committee of the whole? What was third reading? This kind of stuff. So there is this lack of knowledge on how our system operates. And this incident of the last 48 hours has taught me again that recommendation that I have in my Magna Carta is extremely relevant to try to bring our citizens, to be more cognizant of their country and how it operates, because it's only with an intelligent and informed citizens will our democracy be able to sustain itself. Because right now we know it's in deep trouble, and one of the reasons why it is is because most Canadians got lazy 40 or 50 years ago and decided to leave everything to those who they elected, and so they could do anything in those 4 or 5 years that they were in the legislature or in city council without any reference back to the voters. So these are just some examples of it, certainly many others that are in my Magna Carta.
Oh, you had, I want to come back to your lawsuit because that's really important. But one of the things that, just to continue on down that line, is you've expressed very serious concern about the deconstruction, the denigration of fundamental democratic institutions in Canada. And you mentioned a few of them there in terms of the way our legislatures are not working properly. Our federal parliament is still under COVID rules. It's still operating under these ridiculous, not having in-person meetings. And of course, we're going to talk about the Emergencies Act inquiry and the problems there. I want to get there too. But I mean, you're very concerned about our democratic processes, our legislatures not working the way they are supposed to. You want to talk about that a little bit?
Oh, do I ever? And I get shivers. I get goosebumps when you introduce it, because my memory goes back to my first day in the legislature of Newfoundland and how proud and honored I was to be in a Parliament of Canada, of one of the provinces, and how I was able to engage in 1972 in debates as a MLA, and then later as a minister, and how when I became leader and premier, I actually introduced mandatory committees into the House that engaged all of the MLAs. They were called estimates committees. In other words, every department of government not only would have to come to the legislature with its budget as part of the budget that the Minister of Finance brought down, and he would have to defend it, or she would have to defend it. But I went further. I broke it down so that every minister would have, and he could allow his top public servants to be there with him in the legislature, on their oath, giving testimony and answering questions from the opposition about that department's particular budget. And all of the departments and all the ministers had to face the legislature and be questioned by the members of the House. Then when all that was finished, it went back to being the full budget with the Minister of Finance, and then the budget could be debated as a whole and then approved or amended and approved. That was the process. So, and I loved the debates in the legislature, loved them. And I loved the engagement with the other side to, debate a principle or debate an idea that the government was bringing in, or that the opposition opposed, or whatever, or a private member's bill for that matter. For example, in the House of Commons right now, if a member puts in, as an individual member of the House of Commons, puts in a private member's bill, or something that is very concerning to that member and to that constituency that he represents, it may be 2 or 3 years before it ever sees the light of day of debate in the House of Commons. And one of the things in my Magna Carta, I say, is that it has to be debated within 6 months of being introduced, which forces Parliament to get really serious about individual MPs being important, not just being part of a caucus or a party, but individual MPs. They make up the totality of their caucus and so on. And so our institution, our primary institution for democracy in this country, our parliaments, provincial legislatures, and House of Commons in Ottawa, are both become very, very, unparliamentary-like. They are not following the British tradition of how parliaments are supposed to operate, Remember, when we started off our democracy back in the 19th century, we talked about representative government, which was, right, every person should be part of a region of the province or the country and have an MLA or an MP who would get elected and represent them in the legislature or in the Parliament of Canada. 2, we went further back in the 1830s and 1840s to ensure that we had responsible government as well. And responsible government meant that the cabinet and the premier had to come from the legislature. They couldn't be appointed by the lieutenant governor or the governor of the day. They had to also be from the legislature in order to be responsible to the people, responsible government. And so that's our tradition, right? That was very, very important. And so as the parliaments developed, of course, we had these rules and regulations governing the parliaments. And one of them was select committees of the House, parliamentary committees, which had some power. And one of the things that's happened that we've seen in the SNC Lavalin debacle and tragedy and awful scandal is that the parliamentary committee exercised, as we like to call it, and as the founders of the American Constitution talked about, the tyranny of the majority, where the Liberal MPs with the NDP were able to close down the parliamentary committee from hearing valuable testimony from who? The former Minister of Justice and Attorney General, who was trying to ensure that a minister carried out their duties without political interference from the Prime Minister and other ministers. Mm-hmm. And rather than be able to hear Canadians to hear that in a parliamentary committee, our institution, Parliament, it was shut down. And to this day, we have never heard that information that the former minister was to provide to the committee. So that's Exhibit A of how our parliaments are not operating the way they traditionally did. Whereas, for example, today in British Columbia, that bill that's before the House right now, the legislature here, should be going to a committee of the legislature. It's drastically changing the nature of governance of all health professionals in the province. Massive change, where the power is being taken from the health professionals to govern themselves and provide it to the government, who can then dictate whatever they want to all of these professional organizations, as if they weren't professional organizations, like your law society, for example. So what has happened is there's been a deterioration of our fundamental parliamentary institutions, which degrades our democracy and the British parliamentary democratic institutions which we inherited.
And it's not just these parliamentary institutions either. It's also our courts, turning to your mobility rights case. So I know you want to talk about this. So what is happening with the mobility rights challenge that you and Mr. Max Bernier brought? I saw the news, I believe it was yesterday, that you filed an appeal. But what went wrong and why? What's your take on this, Brian?
I kept arguing right up until a few weeks ago, I suppose. Every time I was asked, when I was in a live meeting and in a Zoom meeting or interviews like this, people would say to me, who are highly cynical, don't you understand, after all your years in politics and all your years in public policy, that our whole system is corrupt and there's no way to salvage it? And I would always answer. I would go through it all, and at the end of the day, I would say to them, I want you to understand that until we exhaust all of the levers that we have in our democracy, we cannot say that it doesn't work at all. Yes, there have been things along the way, but I'm relying on the courts. Especially the appeal courts and the courts of the federal government, to bring some sense out of this situation that we're in. And people would go silent and say, okay, we understand it. Because I said, you know what? If I don't do this, or somebody doesn't do this, the other side could always argue you didn't exhaust all of the democratic powers and rights you had. So please, you are not being very fair and democratic yourself if you don't exhaust all of the avenues that are available in the democratic system. So that's why I went to the federal court and challenged the federal government's power to initiate travel restrictions on Canadians, to not be able to travel within their country or leave their country unless they had this particular COVID vaccination and had it up to date, not just one, but however many constitutes being vaccinated today. And so I trusted the courts that they would bring some sense to this situation, that the mobility in Section 6 of the Charter of Rights and Freedoms, which I helped create, that the federal government would see that they had overstepped their powers and they had violated their own Charter of Rights and Freedoms, that they could not really do this, that there was no justification in doing this. And I come back to my favorite mantra is Section 1, which everybody says, hey, I'm glad you're still alive because you didn't do a good job on writing Section 1. And they're ready to jump up and attack me. You didn't have to do it right. And I, of course, go through great lengths to say, hold on one second. It may not be perfect. Nothing is perfect. Let him who's without sin cast the first stone or whatever. My dad used to say years ago, the perfect man died yesterday and another one will be born until tomorrow, and tomorrow never comes. So, I fully understand my fallibility. But there are words in that Section 1 which says, yes, government actions can be implemented that override the Charter provisions of rights and freedoms, individual rights, but you have to go through a number of tests. And one of those, you have to demonstrably justify what you are doing. And Mr. Gray, I remember, I got a good memory on things that I'm really involved in. And I never forget them. I never forget them. And my first job as a minister in the government of Newfoundland, I memorized unknowingly to myself all of the municipal debts of the province, which were somewhere over 200 at the time. Nobody in the department could say, if I mentioned a municipality, what is their debt? Except me. They'd have to go and look up the files and find out whether this town council, this community council, this rural district council, and so on. I could remember. And I did that within the first 3 or 4 months I was there. And I didn't even know I had memorized them until one day one of my staff came in and said, such and such a municipality is looking for a meeting. And I said, well, they're looking for a meeting? This is February 1975. And they were in to see us last July. It's not even a year. Why would they want to come in to see the minister again, in less than a year? And they said, what do you mean they were in here in July? I said, I remember when they were in here. They said, no. Mr. Minister, you got that all wrong. This can't be true. So I said, well, look it up. I said, I think it was the first or second, I think it was the first week of July. And it might have been on a Wednesday. And I think it was 2 o'clock in the afternoon. So I remember when we had a debate, Peter Lougheed, Alan Blakeney, the other first ministers from across the country, when we were debating this charter. And Justified was there. And there was a big argument of whether we should strengthen it. And we insisted, we being Blakeney, Lougheed, Bennett, and myself in particular, Angus MacLean out of Prince Edward Island, quite likely, René Lévesque out of Quebec, quite likely, that it be strengthened. And that's why demonstrably Justify was put in there, because we understood demonstrably to justify to mean you got to go out of your way to prove that this is necessary. In other words, that there's some real benefit that overrides any cost on temporarily delaying the rights and freedoms of certain citizens of the country. This has not been done in the travel mandate that I took the lawsuit out against, nor has, and this must be done not only to demonstrably justify, but within a free and democratic society. And any Canadian knows that if you talk about free and democratic society, you're talking about the parliaments of this country. And how, in our case, the parliaments were really not involved. It became rubber stamps to giving more and more power to bureaucrats. And so the parliament wasn't operating as it should. Mm-hmm. And so therefore, they violated both the demonstrably justified provision as well as the free and democratic society provision. And on top of that, I argue that the beginning of the Constitution, the first words of the Constitution are, whereas this country founded on the principles of the supremacy of God and the rule of law, colon. In other words, what follows must be interpreted and considered in the context of these framework principles of the supremacy of God and the rule of law. And that hasn't been followed. And, unless somebody can show me to the intellectually and rationally to the opposite, I think all of the decisions of the courts since 1982, which have not gone through this process that I've just mentioned, are unconstitutional.
But your case, Brian, was actually worse than that, because the court actually sidestepped that whole inquiry, didn't they? I mean, it seemed to me that the Section 6 violation was pretty obvious, that the court really couldn't get away from that, but they sidestepped the whole Section 1 issue by simply saying that the whole thing was moot. So,
and
so you want to talk about that? Yeah. Yeah,
this is the real corruption of the system, which has led me to not be as loyal to our our laws as they're interpreted by the courts. No sooner had we put in the application, the statement of claim, and established, and that being accepted by the Federal Court of Canada. And then we begin to, as you know better than me, negotiate who's going to speak for who, right? How many lawyers you're going to have, how many expert witnesses are you going to have, and a schedule of hearing all of that. When we're only weeks in, and there was an agreement that it would be an expedited process. One, here's our expert witnesses, here's the lawyers are going to appear. Same for the other side. We're only in a month or more when the federal government comes back to the court seeking to break the agreement that we just had agreed to and that the judge had agreed to. Or we're going to add this many more expert witnesses, or we're going to add this many more lawyers from the Department of Justice. We said, what do you mean? What was the point of all this expedited agreement if you're going to be able to come back? And they came back 2 or 3 times. So early on, after January, February of this past year, it became clear that the federal government had no qualms about abusing the process. A process that we all had agreed to, all 3 parties, the judge, the federal government, and our side. And so, then comes June, and we were getting a little concerned about how the courts were operating with the federal government on this, when then suddenly, because some of the mandates had been suspended, not canceled, but some of the travel mandates had been suspended, that suddenly the federal government comes in with another application which says, oh, by the way, even though we got all this 6 months work done, and 6 million people have had their rights and freedoms abused and denied by the federal government, we have now, the government of Canada has now suspended some of those. So really, there's no need to hear this case. This is all moot now. This is not a live issue anymore because we've suspended, not all of them, but some of them. And therefore, no need to hear this. And there is some precedence for this, or the idea of mootness, as you would know better than me, is part of the court system, if in fact it's really vexatious and there's really no relevance to it. And so we argued back. So therefore, our case gets, the judge sadly agrees to hear this application rather than just throw it out and say, this is vexatious. This is not really relevant to our case because we're talking about rights and freedoms of 6 million Canadians, right? In the last year, not 100 years ago or 50 years ago. So it's very live, very much alive, and it's in the public interest to hear it, as we would argue. But no, the judge said, no, I'll hear it. So the day that we were supposed to have our public hearing part of the court action was the day that they heard the moot case. So our case gets delayed from September 21st to October 31st. And they hear the mootness case in September. And then the judge has the audacity to rule not only against us, but to give no reasons, and took another week or so before the reasons gave, which meant we were very close to where the hearing was to October 31st. So the whole process, and then of course, the reasons came out, and now we are left with no case unless we appeal it. And so we considered it and decided to appeal to the Federal Court of Appeal that the judge erred in doing this, that it was necessary for this judge to hear this case. And our main argument centers around the whole issue of public interest. And, I remember that phrase so well years ago, right? Because public servants, politicians were all there to serve the public. And is it in the public interest to do A? Is it in the public interest to do B? Because we're there to serve the public. And so we are hoping that now at the Federal Court of Appeal, we put the appeal in. We haven't got a hearing date or anything yet. That this will be overturned. This mootness argument will be overturned so that we can get on with our original case of whether, in fact, what the federal government done broke the Constitution or not.
It's hard for me to fathom how the issue could be moot when, as you say, 6 million Canadians were restricted from travel for many months and suffered damage as a result. Just taking your case, I know you live out on the West Coast and you were restricted from travel. You couldn't visit your family in Newfoundland. You couldn't attend certain speaking engagements because Canada is a very vast country, and people are very reliant upon air travel and rail travel just to get around. And so it seems to me, how could that be moot? And speaking as somebody who personally suffered damage from this, because I couldn't travel either, I think most people who watch this program could probably guess whether I'm part of this new disgraceful subclass of Canadians known as the unvaxxed. But I mean, how could this possibly be moot? Because all of us have suffered very severe damage, regardless of whether or not these things are reimposed upon us. And sadly, it's looking like, the dragon is going to emerge from its lair again. We're going to have to slay smog again.
And for someone like me who became so public on this, and some older people remembered when I was a first minister, and others who heard interviews like this one that I did with you before, and I've done now over 150, quite likely around 160, either live or Zooms in the last year. Okay,
fantastic.
On the very issue, and therefore I started to get numerous phone calls because my phone number is public and my email address is public, and so right to this moment, to this day, I'm getting between 20 and 40 emails an hour.
Oh my goodness.
And so my point is this.
Your poor wife.
Yeah, well, exactly. We're waking up in the morning at 7 and we're still at it at 11 in the night. I mean, it's crazy. So my point is this. I've had calls and I have had written letters to me from people who have been hurt by this travel ban. A gentleman from Ontario drove out, because he was unvaccinated, drove out to British Columbia to see a dying relative on Vancouver Island. About an hour and a half drive from where I live. And he had an accident after he arrived out here and injured his shoulder and so on. He had to get into the medical system here. Of course, that took some while. Meanwhile, he was supposed to be back in Ontario to his job. And he promised his employer, I'll be gone this long. I'm going to see my relative was very sick. And then I'll drive back. And here's how long it'll take me. So, 10 days or whatever. And you can take it out of my holidays or whatever. I'll be back. Well, he called him and said, I've had an accident. The accident wasn't my fault, but I've had an accident and I've gotten injured. And therefore, I won't be back soon. So I hope you'll understand and so on. They did not understand. And he lost his job.
Oh, boy.
Now, to get his job back, of course, he'd have to go to court or whatever. So he called me and wrote me about this. And I had two young ladies whose aunt lived in Australia and who was passing away. And they were very close to their aunt. And they wanted to, and she had contacted them and said, I don't know if I'm going to make it or not. She was very sick. And I'm sending you the money to come and see me. They couldn't fly. They couldn't get to Australia. And their aunt passed away without seeing her relatives before she left this earth. So I had mountains of this kind of information. So I'm sitting here and listening, and the lawyers are calling me, and I'm listening to all of this stuff that the court is saying. Well, I'm glad I'm not in Ottawa or physically close to any of those judges, because I don't know what I would do. I mean, people's lives have been permanently damaged by what this federal government has done just on this travel mandate and how it has affected people's lives forever. And then this judge can stand up and talk about mootness.
I know you talk about losing faith in the judicial system. I'm one who's very concerned about judicial activism. As you know, the traditional role of the courts under our Constitution is to be interpreters of the Constitution and to apply the legislation to a given set of facts. That's their role. Unfortunately, there's a school of thought that's come out of the 1960s that was really authored by people like John Rawls at Harvard, this idea of distributive justice. And it's ushered in a whole era of judges who have it in mind that it's their job to actually create law. And this is very undemocratic. Yes. We had a lady on this program recently named Karen Selleck. She's a former lawyer. And she's a commentator, but she actually was one of the lawyers who wrote a complaint about Mr. Justice Wagner's comments that I know you're familiar with, where he expressed some very strong ideas about the people like you who were at the Freedom Convoy, involved in the Freedom Convoy. And she filed a complaint. She and some other lawyers filed a complaint with the Judicial Council. Well, Brian, you'll never guess who at the very apex of the Judicial Council. It's Mr. Justice Wagner. So what do we do? Everywhere we go, we see this. Maybe corruption is the wrong word, but we see that this top-down dictatorial structure of our institutions. They no longer function in a way that they are democratic, where there's accountability to the public.
How can that be? I was wondering what happened to some of these complaints that went into the Judicial Council. I remember putting it on my blog a few times. I didn't know what happened. I know of Karen, and I spoke to her a year or so ago, and she expressed a great deal of concern about my reference. I was talking about all the premiers can refer their mandates and lockdowns to their highest court to get a determination as to whether it's constitutional or not, but they all turned down. She was concerned about that because she thought that was giving them too big an opening. She was opposed to what I was doing at the time. I was familiar, but I was familiar with her name before that. But it just boggles the mind to think that this kind of conflict of interest and undemocratic process can happen at the highest echelons of our judicial system, and then for us to go around preaching about democracy and telling people in other parts of the world how they should behave in order to be a democratic country. It's incredible, and gets to the heart of why I've been so vocal about all of this, and you have been so vocal about all of this. To think that that can happen in Canada or happen in any so-called, parliamentary democracy under the British system, boggles the mind. It's unbelievable, and when you look at, and I know you want to get into what has happened in these inquiries and so on.
Yes.
I mean, the same kind of thing is happening.
It happened. Apparently, it happened just yesterday. There was a lawyer, and I believe it's Justice Rouleau is the one who's presiding over this inquiry. There might be another word for it in Ottawa. So this lawyer actually was questioning, wanted to have certain witnesses appear, and the court said procedurally that they would not deal with this procedural question. And when the lawyer pressed the point, the lawyer was thrown out of the inquiry.
Yeah, I watched it.
To me, it's appalling. So
And then
Brian,
they had to
by way of
apologize
segue,
because he spoke over the judge.
right. So what is going on? Because I know you have some very pointed comments. What's going on at the Emergencies Act inquiry?
Well, the Emergencies Act is wrong. The inquiry is wrong. And I think this is one of the areas where Canadians don't get it. I'm getting more robust in my phraseology.
Okay, tell us how we can understand.
Canadians don't get it because I don't know who else wrote a big long essay on the Emergencies Act being flawed, but I did, and I went through it clause by clause. Here is a government who's establishing an inquiry and establishing the terms of reference of that inquiry and appointing who is going to be the commission to examine itself.
I'm starting to see a problem here. Yeah, I'm starting to see a problem
here. So, yeah. But we're all everybody's participating in this inquiry as if it was legitimate. It's illegitimate. And the first thing out of the gate that everybody should have said was, no, we're not going to participate in this flawed process. And the opposition parties should have been up in the House of Commons and putting in amendments to the Emergencies Act to say, yes, we want to have this, we want to have a legitimate inquiry into what happened, but this is not a legitimate inquiry, and we want to amend this act so that it does. Now, let it fall, let it rise or fall on whether the government, Liberals and NDP, want to go along with it. But it would expose the hypocrisy and the falsity of this Emergency Measures Act. It is this Emergency Act. To have the government establish the terms of reference for an inquiry as to whether they were doing things properly or not under the Constitution speaks volumes about the decay of our democracy as we see it today. And it was inevitable near the end of this inquiry. Look how it's set up, eh? Who's got the last week of the inquiry? All of the ministers, culminating with the Prime Minister at the end, right? It's all a play, as I said in my blog a couple of days ago. It's a play, all well orchestrated to ensure that what comes out of this is the decision that the government wants. And I mean, of course, this Mr. Rouleau, God bless his soul, I'm sure he had a great life and all the rest of it, but he's been appointed by these very governments who approved and proposed this legislation and has been involved in the judiciary in various parts of Canada. So he's hardly an independent soul in this whole thing. And so, this is just awful. And by the way, to show you just how wrong this whole thing is, just let me cite two really important things. Part of the lawsuit on the travel mandate has, even though it was an expedited one, I was still allowed to be cross-examined. So my lawyer, Keith Wilson, and the others from the Justice Center, in a conversation with the government lawyers when the case was ongoing, were looking at that 5-day window of public argument by both sides that was supposed to start on September the 21st, and said to the lawyers, I guess you're looking forward to the day when you're going to get Mr. Peckford on the stand and be able to really go after him, because he's been so vocal about this, right? And that about Section 1 and so on. Now you'll have the chance, because you're so confident of your position, that you're going to want to get him on the stand. He's our star witness. Boom, and we'll destroy him. So when one of those 5 days do you think you will be calling Mr. Peckford? Oh, we don't intend to call
him. I wonder why.
Exactly. And in the inquiry, in the flawed inquiry, the lawyers had put my name in it, proposed my name as one of the witnesses. Now, why did they have my name in there as one of the witnesses? What did I have to do with the convoy per se? Oh, I was down to Ottawa. I flew down to Ottawa. I participated and spoke in front of Parliament, outdoors, right, at a rally, a freedom rally, supporting the truckers, right? And I participated in a press conference foreshadowing, because we got a leak that the government was going to impose this Emergency Act, and took part with the head of the truckers' convoy to Marystown in a press conference highlighting the fact that what the government is likely to do in the next few hours or next day in imposing this Emergency Act was wrong and unconstitutional. Well, who better to have then in the inquiry as a witness to see what the government did is right or not than somebody who was in Ottawa, who participated as a main speaker in opposing what the government was doing and supporting the truckers, and who was involved in a press conference about the imposition of the Emergencies Act. Who better to have as a witness than yours truly? And they refused to appoint or allow me to be a witness on the inquiry.
Just to throw another log.
Examples.
Yeah. Well, here's another one. I'll throw another log on that fire. In the Ingram case in Alberta, we applied to have you have an affidavit that you had sworn, entered into evidence there, and the court there said we couldn't do it because the fact that you were involved in the very creation of the Canadian Charter of Rights and Freedoms, and the fact that you helped to craft Section 1, which is the main question she was going to be deciding in the case, that still made all of your evidence irrelevant. So there's another log. I don't know if you knew that, Brian. That's another log on the fire. So it seems nobody wants to let the mighty Casey up to bat.
I mean, it's absolutely incredible. I was salivating, to have the opportunity to give a fulsome description of the Charter of Rights and Freedom as I understood it from the days when I helped craft it over those 17 months, right? It wasn't like it was just done overnight either. It was a long process that we were involved in. So there you have it. So when I talk to our American friends, there's 2 or 3 different groups in the United States who call me all the time, and I do Zoom interviews like this because they're really keenly interested. And when they understand that their people say, we have the interview set up with Mr. Peck. We do have Mr. Peckford coming on our show. And when I get on the show with them, they say, we consider you. If you were in the United States and you were one of the people who helped amend our Constitution 40 years ago, I mean, this is incredible. We don't understand how.
Yeah, you'd be like John Adams or something.
Yeah, you'd be like the Jeffersons, or you'd be one of the fathers of the amendment to the original Constitution.
Exactly.
And this morning, one of these people, funny, I should get into this. One of these people wrote me an email this morning. Out of the hundreds I had this morning, this guy writes me from Nebraska, I think is where he is. And he says, Mr. Peckford, I was just happening to be thinking about you overnight. And he said, I wanted to before Thanksgiving and Christmas and so on, just to say to you how grateful we are that you came on our show 2 or 3 times this past year. And we hope you have a wonderful Thanksgiving and Christmas and so on. And we really applaud your intervention in what's going on as it relates to the pandemic and the Constitution, because we think it's really important.
Wow.
Right out of the blue.
Wow. So, Brian,
that was an American.
This concept of a public inquiry, though, is something that you and others think is very, very important. And I know Preston Manning is someone who has been trying to develop or has been involved in developing a concept for a proper public inquiry. Do you agree that a true public inquiry about COVID-19 and the government's mismanaging of it is really, really important for the country? And if so, why is that so important in your view?
Well, because the governments were so involved in the pandemic with their special health orders, both at the provincial, territorial, and federal level, that to expect any of these governments, therefore, to be able to have the credibility necessary for some kind of public inquiry to get at the bottom of how much of this was necessary, how much of this was constitutional, how much of this was following the science. It begs the whole question of what ethics and conflict of interest are all about. And so in my Magna Carta, and I held off on this because I knew quite likely this was coming, that was the first thing that I proposed, that there needs to be a citizen-led national inquiry. One of the problems we had early on is that most people talked about a federal inquiry. And I was very insistent that a federal inquiry could only deal with the federal mandates, would not deal with the mandate in BC, which is different than the mandate in Alberta, Saskatchewan, and whatever. And that, unfortunately, a lot of Canadians have come to understood federal as being national. But as you know, as a lawyer, and I know, as being involved in public policy.
I think Mr. Trudeau is under that impression too, Brian.
Exactly. The federal is one thing, national is something entirely different. And that's why in my talks, I always talk about the Constitution being national, whereas the Bill of Rights was federal.
Right. Yeah.
The Bill of Rights of 1960 was federal. It only applied to federal law. Important, very important, but it had its limitations. And so it's very important, therefore. And so I was able to persuade most of the people who were, especially people in Ontario, and other people who are only involved federally, they get this cloak on of understanding federal as well. That they take care of it. And so I was very insistent that it be a national inquiry. And I'm glad that through the process, this is what has evolved. And now we have a national citizens inquiry created by individuals and groups across the nation come together. And hopefully we'll be able to raise sufficient funds because there'll be no government money involved. So the public of Canada will have to finance this national inquiry and then establish commissioners and have 7 different hearings across the country to represent the various regions of the nation, and have people come to those inquiry who are either scientists or researchers and do the science part. People like me and others, yourself or whatever, attend the one in your area to argue the constitutionality of what happened or the unconstitutionality of it, and regular citizens who have a point of view. And then have these commissioners then come together and formulate a final report as to how they see this happening of the last 2 years. What was necessary? What wasn't? What can we learn from it? What was legal? What was constitutional, and so on. And so, thankfully, it's established. The great question now is if Canadians will really get behind it, because you don't want to start to have to reduce the number of hearings. You don't want to start to have to reduce the number of people who are going to be involved in this. One of the other big obstacles we have, of course, is that it will be very difficult to get access to the data from the departments of health provincially or the federal Department of Health and the Public Health Agency of Canada. That's one of the drawbacks. But one would think that in a democracy, and if all of these political parties are interested in democracy, as they keep pronouncing all the time, they will ensure. And, here's a great obligation on behalf of the MLAs and MPs across this country. Bring in resolutions in your legislatures demanding that government of that province or in the federal government release all of the information that this National Citizens Inquiry might want. For example, Mr. Polyev, the new golden boy of the conservative movement of Canada, if he's really interested in being different, as a lot of his supporters continue to argue, here's his moment. Put in a major piece of resolution to the House of Commons today, tomorrow, demanding of the federal government and the Liberals and the NDP that they release all information that this citizens-led inquiry requests of them after the inquiry gets established. That's what they could do tomorrow. So talk about having a democracy work. Here's a place where the politicians can get back involved by supporting the National Citizen Inquiry through their parliaments.
Well, Brian, I kept you almost 2.5 hours last time. I promised your lovely wife and handler I would not do that to you again, but it would be negligent of me not to ask you the corollary question, which is, what are your thoughts about this idea of amnesty versus accountability for the people most responsible? I'm talking about the Dr. Fauci and the Dr. Tam, and what's your view on these calls for a general amnesty? Because we didn't know enough at the time to know that we shouldn't have done lockdowns and vaccination mandates and so on.
When I look at what happened to Dr. Hoff in Leighton, BC, when he was deprived of his livelihood, visitation rights to the hospital in Kamloops, because he was declared by somebody to be a vaccine skeptic. And everything that happened to him since, and to him to still be standing nobly, or, there's many others across the country, Eric Payne, right, in Alberta. There are many across the nation. Dr. Brian Bridle, for example, is another really good example. All these people who have lost their incomes and their livelihood, their reputations among certain groups of people in the country, it behooves the citizens and the taxpayers to ensure that those who are responsible for this are brought to justice. And so I have very little. If this was a minor kind of incident somewhere in one part of Canada and got all mixed up, you may have some sense of forgiveness. I remember being on a little baseball field, well, just an old field that we made into and put up some rocks as a goalpost years ago when I was 7 and 8 years old. And a number of people of my boy guys who were playing soccer or something started to break some of the rules. And I remember saying, I'll never forget it, I remember shouting and actually crying because they wouldn't change. You weren't being fair. Fair goes both ways. And it is not fair to the people of Canada and to our democracy. It's not fair to say that all of these people, because there's another point in law, I guess, that I read in a lot of court judgments that I've read, ought to have known.
Right.
In my speech in Calgary, I mentioned Dr. Douglas Allen.
Oh, yes.
Of Simon Fraser University, who reviewed 80 studies back in April 2021 and determined that as early as August 2020, there was ample information for the policymakers to know. And
Brian, we had to
was worse than the disease.
Yeah, Brian, that study, we had to fight to get that study into evidence in Ingram. We had to fight to get it in. The government wanted to keep it out. Yeah, it said that lockdowns were the greatest public policy mistake ever.
Yes, I quoted
People
that
should
in
read
my
that.
Alberta.
Yeah, people should read that. It's brilliant. Yeah.
And it's never mentioned hardly anywhere.
No.
It should be mentioned more. It should be. I can't understand it. I mean, it stands there as and nobody's ever attacked it and diminished its credibility from that day to now. And so,
and it was also vindicated by a Johns Hopkins study that came out earlier this year, which was a meta-analysis of, I believe, over 34 studies. Yes. By the way, the judge in Ingram ruled that meta-analysis was inadmissible simply because it was released after the period during which the lockdowns had occurred. So yeah, this is unfortunately, the truth is hard to come by, and it's even harder to get into evidence in a court of law, unfortunately.
Well, and
but Brian, I want to say,
I know,
go ahead.
And personally, I know all about this business of where fairness comes in,
right?
And how somebody had a vendetta against me, and after I was out of politics, we suddenly get in the mail a bill for tens of thousands of dollars of back taxes.
Oh, really?
When I was Premier of Newfoundland. I've never mentioned this on a program before. I don't know I don't think I've ever made it really public. And I looked at Carol, and Carol looked at me, and we had chartered accountants through all my time in public office, both the party and myself. And we had gone and gotten decisions out of the tax court and out of the Revenue Service, out of the Revenue Canada, so that we were sure of what we were claiming or what we weren't claiming was legitimate. And here we get this huge, big bill. Well, here I am having to fight my case, right? And so now I'm going to, and of course, at the end of the day on that case, I got the chartered accountants to withhold the decisions that we had gotten from the Revenue Canada and so on, and just went back on my behalf and just said to them, please review your information, review all of the material, all of Mr. Peckford's tax returns from the day he was leader to the day he wasn't any longer leader or premier, okay? And go through them all and make sure you know what you're talking about, because you've done something that if Mr. Peckford wasn't a different ilk, he could bring you guys into, cause you a lot of problems and cause your political masters a lot of problems. And he's trying to be fair here, and so he's received this, and so he's back. It took 2 or 3 meetings, and they still came back, regional manager and so on, came back saying no. And so I had the lead guy from a major chartered accounting firm sit across the table and produce the letters. And when they saw the letters, it was just red faces all over. Red faces all over. So my chartered accountant said, all Mr. Peckford requires is a bill for zero, and included in that bill is a written apology, which I got.
Oh, well, it's good to hear somebody beat the revenue man.
But my point is, I'm sitting here today, and I'm hearing about these thousands of people who were hurt, whose lives livelihoods were lost, whose lives were destroyed, who didn't see their loved ones, and all the rest of it. And I'm supposed to now pursue a pathway whereby all these people who knew or ought to have known to be completely excused from all of this problem and disaster that they've caused. Sorry. Fairness demands.
Well, I certainly agree. I certainly agree with that. Brian, I want to thank you so much for coming back on the program and talking to us again. We've learned a lot more about these topics. Now we're turning to a part of the show, of my show, I know you really enjoyed. I don't know if you remember this. It's called the Reading List. And having talked with you before, I know that you're a fan of certain authors. And so I'm going to go first, and then you're going to going to turn to your vast library and give us some ideas. So my first one is from a late British author whom you and I both admire very much. It's the late Dr. Roger Scruton, who's written many books. This one you're probably familiar with. It's not as well read as some of his other ones. It's called The Soul of the World. And I mentioned this one because it defends the experience of the sacred against today's fashionable forms of atheism. And I know that you feel very strongly about the supremacy of God. You've talked about that a lot, the importance of that in our Constitution. And here, Dr. Scruton argues that our personal relationships, moral intuitions, and aesthetic judgments hint at a transcendent dimension that cannot be understood through the lens of science alone. This is very important in terms of COVID. To be fully alive and understand what we are is to acknowledge the reality of sacred things. Rather than an argument for the existence of God or a defense of the truth of religion, this book is an extended reflection on why a sense of the sacred is essential to human life and what the final loss of the sacred would mean. In short, the book addresses the most important question of modernity, which is, what is left of our aspirations after science has delivered its verdict about what we are? So that was one that I thought is particularly relevant to some of the causes that you're talking about. The other book is from another thinker whom I know you admire very much. This is Dr. Thomas Sowell of the Hoover Institute. And he's written he's written more books after the age of 80 than most people have read. Yeah. I think he's 91 now. Anyway, one of his wonderful books that I read recently is called Knowledge and Decisions. This is not one of his newer books, but it's brilliant. And the description of this book, Sowell is one of America's most celebrated public intellectuals, also one of the most attacked, describes in concrete detail how knowledge is shared and disseminated throughout modern society. He warns that society suffers from an ever-widening gap between first-hand knowledge and decision-making, a gap that threatens not only our economic and political efficiency, but our very freedom, because actual knowledge gets replaced by assumptions based on an abstract and elitist social vision of what ought to be. And that seems to be a great way to describe what's going on in Ottawa right now with the Emergencies Act inquiry. So, Brian, those are my selections, somewhat in honor of your appearance. Can you give us a couple from your library or from your memory that would help people in terms of their understanding of some of the things you've been talking about with us today?
I'm so happy that you quoted those two authors because they're two of my favorites.
I do homework, Brian. I don't know if it shows, but I do my homework.
I still have on my Kindle here, and I go back to it all the time. Roger Scruton's description of conservatism.
Oh, yes.
He did it. Yeah. That's a beautiful book, and I go back to it all the time. I've read just about all of Mr. Sowell's books.
Yeah.
And the other one that I really like is Conflict of Visions.
Oh, yes. Okay.
That's a beautiful book. That's a beautiful book that Thomas Sowell wrote. And I also still have that here. So the other new book, which is not from any of the great thinkers, but which everybody who is interested in science and the pandemic should read.
Wow, I haven't seen that one yet.
This
Turtles
is
all the way down.
This is it.
Wonderful.
This is it. Vaccine, Science, and Myth.
I knew you would have something that we hadn't read yet. Turtles all the way down. Awesome.
Turtles all the way down. The authors are anonymous. They're out of Israel and knew that if they published this, given what was happening in Israel at the time and is, that they would be condemned.
Wow.
And so they remained anonymous. And some people in North America has gotten hold of all of the transcripts and got a permission to carry it. And so this is the Children's Health Defense people, Robert Kennedy Jr.'s people.
Right.
Forward by Mary Holland and edited by Zoe O'Toole and Mary Holland. This is a beautiful, beautiful book of fact.
That looks like a reference to the Dr. Seuss story, Yertle the Turtle, on the cover.
Well, it has to do with the separation between one's ideas of the world and how scientists said, there's a story in there, which refers to how the title came about, and how a scientist had talked about the data that was available to show that the Earth was round. And this person spoke up and said, but it is not round. It is flat. And it's just full of turtles all the way down. One turtle on another turtle on another turtle. Falsity. And the gap between, and this was to demonstrate the gap between real science and non-science.
Right.
Turtles all the way down.
Yeah.
It is an absolutely beautiful book. I'm not reading it. I'm studying it. And you can see I'm only partway through it. That there, by the way, is my bookmark for my
wonderful.
My book.
Where can we get one of those? Can we order those from your website?
No, you can't. But I have some here. I could put some in the mail to you.
No, I'd love to have one. Those are great.
Yeah.
Well, thank you so much for those selections. Do you have another one?
No, I'll stop there because if I get going,
I want to save it for next time because I also wanted to talk to you. We sort of touched a little bit there on censorship. I want to put that off to the side for the next time because next time I want to talk to you about the new censorship bill. Yeah.
Yes, because then we can talk about another great thinker, John Milton and
Areopagitica. Yes, absolutely. Yes. I just quoted him in an essay that I wrote recently.
You did. Yeah. I saw it.
Yeah. Well, thank you so much for being with us, Brian. As always, it's an absolute pleasure to talk to you and to mine your ideas and your vast knowledge of the Canadian politics and polity and constitutional history, and now constitutional law, because of course you've made this grand foray into that arena. And I wish you tremendous luck with your appeal. I know you have an excellent lawyer, and you have an excellent case. And I just pray that a court next time is actually going to hear it and grapple with these very important legal issues that affect millions and millions of Canadians.
Okay, sir. Thank you very much for having me. You have a wonderful day, and we'll talk to you soon.
Thank you, Brian.